Hello everyone, welcome back. Let us begin with the basic idea of liability in torts. First, understand the word liability. Liability simply means legal responsibility. When the law says that a person is liable, it means that the person is responsible in the eyes of law and must face the legal consequences of his act. In tort law, liability arises from a civil wrong. A civil wrong means a wrong committed against a private individual and not against the state. This is why tort law is civil in nature and different from criminal law. Basically, in criminal law, the main object is punishment, but in tort law, the main object is compensation. The law wants to ensure that the person who has suffered harm is properly compensated. Liability in torts arises because of a breach of legal duty. The law imposes a duty on every person to act carefully and reasonably. If a person breaks this duty and causes harm to another person, liability arises then. For example, if a driver drives carelessly and injures a pedestrian, the driver has breached his legal duty to drive safely. Therefore, the driver is liable in tort and must compensate the injured person. Now let us understand the basis and types of tortious liabilities. Liability in torts does not arise in the same way in every situation. Different kinds of harm require different legal principles. Therefore, the law classifies tortious liability into different types. Broadly, tortious liability is divided into four main categories. They are fault based liability, strict liability, absolute liability, and vicarious liability. Sometimes liability arises because a person is at fault. Sometimes liability arises even without fault. Sometimes a person is liable for his own act, and sometimes he is liable for the act of another person. This classification helps courts decide when and how liability should be imposed. Now let's look at fault based liability. Fault based liability is the general rule in tort law. Under this type, liability arises because of fault on the part of the defendant. Fault usually means negligence or intention. Negligence means carelessness or failure to take reasonable care. Intention means doing an act deliberately to cause harm. In fault based liability, it is necessary to prove fault. The injured person must show that the defendant was negligent or acted intentionally. For example, if a driver overspeeds and causes an incident, the driver is negligent. If another person is injured because of this negligence, the driver will be held liable. So, in fault based liability, the fault is the foundation of liability. Now, let us move to strict liability. Strict liability means liability without fault. Here, it is not necessary to prove negligence or intention. This principle was laid down in the famous case of Rylands versus Fletcher. According to this rule, if a person brings a dangerous thing into his land and that thing escapes and causes damage, he will be held liable. The idea behind strict liability is that a person who keeps dangerous things should be responsible for any harm caused by them. However, strict liability is not absolute. There are certain exceptions such as act of God, act of a third party, or the plaintiff's own fault. For example, if a chemical escapes from a factory due to the sudden earthquake, the factory owner may not be liable because earthquake is an act of God. Now let us understand what is absolute liability. Absolute liability is stricter than the strict liability. It means liability without fault and without any exception. So here in absolute liability will not be having any exceptions, whereas in the previous strict liability there may be exceptions due to act of God, that is kind of earthquake. In this absolute liability, the principle was developed by the Supreme Court of India in the case of MC Mehta versus Union of India, also known as the oleum gas leak case. This liability, absolute liability, applies mainly to hazardous and dangerous industries. If such an industry causes harm, the owner is fully responsible. For example, if a poisonous gas leaks from a chemical factory and people are injured or killed, the factory owner cannot take any defense. He will be absolutely liable to compensate the victims even if all safety measures were taken. Thus, under absolute liability, responsibility is total and unavoidable. Now, let us look at vicarious liability. Normally, a person is liable only for his own acts, but under vicarious liability, one person is held liable for the wrongful act of another person. This type of liability arises because a special relationship, such as employer and employee, owner and driver, etc. Of the basis of vicarious liability is control. Since the employer controls the work of the employee, the law holds the employer responsible for acts done by the employee in the course of employment. For example, if a delivery driver causes an accident while delivering goods, the employer can be held liable even though the employer was not personally driving the vehicle. This principle ensures that victims get proper compensation. Apart from these main types, there are some other forms of liability in tort law. One such form is tort features, where two or more persons commit a tort together. In such cases, each person is jointly and severally liable. Another form is breach of statutory duty, where a duty imposed by law is violated and harm is caused. There is also injuria sine damno, which means legal injury without actual damage. Here, violation of a legal right itself is sufficient to create liability, even if no actual loss is proved. So, to conclude, liability in torts is about fixing legal responsibility for civil wrongs. The main aim of tort law is to compensate the injured person and ensure justice. Different types of liability exist to deal with different situations and kinds of harm. Ultimately, tort law promotes responsibility, fairness, and accountability in society. If you found this video helpful, please like, subscribe, and share. Thank you for watching.